Students, I welcome you all to Clat lecture series. This is a test practice series. Lecture number 4. These classes are sponsored by Sri Jain the Rank Zone. I am your mentor Shekhar Galot. Let's start with the question. X went to Y's house and forgot his bag which contained 1 kg sweets. Y's children consumed the sweets. Decide the liability of Y. Y is bound to pay the price of sweets to X. Y is not bound to pay anything. Y is bound to pay half the price of sweets. Y would not have to pay anything because X loves Y's children. See, these could be an option if we are not talking in the legal terms. If we are talking in the legal terms, we keep all the all the uh, realistic considerations side. We talk only about law. So legally, if X wants, Y will be bound to pay the price. So most appropriate option here is Y is bound to pay the price for sweets. Okay. So practically nobody would, in real situation, nobody would ask for the price. But if somebody is asking, then legally X would become liable, Y would become liable. So we'll go with option A. Y makes an attempt to steal some jewels by breaking open a box and finds after opening the box that there is no jewel in it. Now he tries to steal some jewels, but there were no jewels. Now find the appropriate answer. Y is not guilty of attempt to theft because the box was empty. Now is Y guilty of attempt to theft because he would have been guilty if there were jewels, but there were no jewels. Y is guilty of attempt to commit theft. Y is guilty of trespass. Y is not guilty of an offense. Okay, so see, he has the intention to steal. So some offense he has committed. So this option goes off. Y is guilty of trespass. Yes, trespass can be an answer here. Trespass to goods. Okay, trespass to goods. But we are talking about offense here. Okay, we are talking, he has committed an offense, we are talking about an offense here, we are not talking about torts. Meanwhile, so we'll ignore trespass. Okay, Y is guilty of attempt to commit theft. Y is not guilty of attempt to commit theft as the box was empty. But we have to punish, like we talked about, actus rea plus mens rea. So his mens rea is he's trying to steal. His intention was to steal, but he could not steal somehow. Did he act in order to make a steal? Yes, he act. He tried to steal, but he could not steal as the box was empty. But yes, he wanted to steal. So definitely he has made an attempt to commit theft. So we'll go with answer B here. Which one of the following is not correct? Freedom of speech and expression includes freedom of press. Right to life and personal liberty includes right to carry on any trade and profession. Right to equality includes the principles of natural justice. Freedom of conscience includes the wearing and carrying of kirpans by Sikhs. Yes, this is freedom of conscience, freedom of religion. Right to equality includes principle of natural justice. Yeah, principle of natural justice means you have to fair, okay, in your decision making. So fairness, yes, fairness is part of equality, so it is a correct answer. Right to life and personal liberty includes
It's
the
10
right to
o'clock.
carry on any trade and profession. Now this becomes a wrong answer. Why? Because though we have a right to carry on any trade and profession, but it is actually a right to freedom. Okay, it is a right to freedom. It is under Article 19, but right to life and personal liberty is Article 21. Okay, so this option does not go hand in hand. Both are right. Both rights are there, but both rights are provided in different articles. So you cannot club two articles here. So this is not a correct answer. So this is not the correct answer. Freedom of speech and expression includes freedom of press. Yes. Mr. Samay was severely hurt while working in his factory and felt unconscious. So he is hurt while working in the factory and he fell unconscious. He was rushed to a hospital by his fellow workers. In the hospital at emergency casualty ward, the doctors opined that he should be operated immediately. While conducting preliminary examinations, he was found to be HIV positive. The doctors are in dilemma regarding what should they do first. Doctors should operate first. Doctor should inform his family members. So yes, they have to inform the family members because the person is HIV positive, and the family members are in close contact with the person, so they may get infected. Doctor should inform his employers. Yes, they should inform the employers as well. Doctor should not inform anyone because it would violate patient's right to privacy. So, an HIV patient does not have a right to privacy. In such a scenario, they have to tell the people who may come into the contact, just like a COVID patient. Okay, so this is not a good option. So yes, this is a good option. They have to employ, but the question is, what should they do first? So they should first operate. That's it. Okay, doctor should first operate because he's in an emergency situation. They have to operate, and they can inform the family and employer later on. In which of the following cases can a constitutional amendment be passed just by a simple majority in parliament? Now we discussed we have different kind of majorities in the parliament. We have one which is called a simple majority, in which the laws are passed by a simple majority, that is 50 more than 50% votes, or then there is a special majority, that is 75% votes. Okay, that is two-thirds of the members present and voting. Then there is another kind of majority which is two-thirds of the total strength, that is 75% votes of the total strength. Okay, so there are three kinds of majorities. So out of these, what matters can be decided by a simple majority? Election matters. Election matters are very important matters. They cannot be passed by a simple majority. Okay, changes in the name and boundaries of the states. Powers of president, none of the above. None of the above is usually not a good option to go with. So powers of president, if president is a important part, important functionary of a parliament, so you cannot change it simply by a simple majority. But change in the name and boundaries of the state, though it's also an equally important matter, but Constitution Article 4 specifies that change in the name and boundaries of the state can be made by just a simple majority in the parliament. So yes, this is the answer here. We'll go with option B. In which of the following cases the person is not guilty of any offense? An adult man kills another person with knife. An adult woman kills her newly born child. A man of 75 years of age commits rape on women. A child under the age of 7 years shoots his father with a revolver and the father dies. Now, where the person is not guilty of any offense? See, we discussed a term called doli incapax. That means a person who is incapable of committing the offense. So I told you that we treat a child who's under age 7 years old, he is unable to commit a crime. So even if he's committed a crime, then we'll not treat him as a criminal, or we'll not treat him guilty of the offense. Okay, so yes, offense has been committed in all the situations, and all people are guilty of committing an offense in different capacities. But here the child, because he is doli incapax, though he has killed his father, but he will not be guilty for it. So our answer is option D here. A knows Z to be behind the bush. B does not know it. A induces B to fire at the bush, knowing is likely to cause Z's death. Z dies. A is guilty of what? Abatement to murder, culpable homicide, attempt to murder, none of the above. So, abatement to murder, that means he told Z that you kill him. Then, if he would have killed B, okay, sorry, if A would have said to B that you kill Z and then he would have killed Z, then it was a abatement to murder. Okay, but here what he has said B that you shoot behind the bush, and he shot behind the bush. B does not know why A is saying so. Okay, A may have made so many stories. So B does not commit a murder here. A is doing something. So his act is culpable homicide. Culpable homicide means guilty homicide means killing of a man by another man. So yes, A is definitely guilty of committing. Attempt to murder will not be a case here because Z dies. If Z would have survived, it would have been attempt to murder. But Z dies, so now it becomes culpable homicide. So our answer is option B. The President can obtain opinion of the Supreme Court in which of the following cases? Where he is advised by the Cabinet of Ministers to refer the matter to the Court for its opinion, where he is advised by the Prime Minister to refer the matter to the Court for its opinion, where the question of law or fact has arisen or is likely to arise, which is of such a nature and of such public importance that it is expedient to obtain the opinion of the Court. C. President can do so in this case as well, in this case as well, and in this case as well. But the mode prescribed in the Constitution is the option C. Constitution talks about this option. Okay, so we'll go with answer C here. You will have to read the Constitution and some important parts of the Constitution carefully as well. You have to even do some mucking up if question comes straight like this. Which constitutional right is not a fundamental right? Right to equality, right to freedom, right to life, right to property. Now we have right to equality, 14. Right to freedom, we have 19. Right to life, we have Article 21. But right to property, it is merely a constitutional right. It is no longer a fundamental right. Earlier it used to be a fundamental right, but in 74 it was taken out from the basket of fundamental rights and put up with the other constitutional right in Article 301. So now it is not a fundamental right. So our answer is going to be option D. Here. X is accused of rape. What defense is permissible to him according to the law? What defense can he take as per the law? They love each other and want to marry. He lost his control under circumstances. She consented to the act of sexual intercourse. None of the above. So they love each other and want to marry. This is not a justification for committing rape. He lost his control under circumstances. No justification of rape. She consented to the act. That means she was willing party. This is a valid consent in the law. Okay, so this is a valid consent in the law, that valid defense in the law. So we'll go for answer. That answer is C. Some of you may be confused with option A, but you'll have to read the question carefully and then you'll have to understand the options as well. A, without excuse, fires gunshot into the crowd of persons. This should be crowd of persons and kills two of them. A is guilty of what? Murder, causing death by negligence, culpable homicide, or no offense at all. Now here no offense, definitely he has committed no offense, so this is not an option. Culpable homicide, causing death by negligence, so he is shooting himself, so there's no negligence, there's a positive act, so we are left with murder and culpable homicide. So culpable homicide and murder, we discussed that there is a difference. Culpable homicide is when you accidentally kill someone. Okay, you have intention, but you do not have intention to kill. You have intention to teach a lesson, but somehow he dies. You inflict some injury and he dies. But murder is when you intentionally kill. So when you are firing in the crowd, you know that people will get killed. So it becomes a murder. So option 76 is the option A is the most appropriate here. Now this is a constitution plus GK question. What is a 0 hour in the parliament? So 0 hour in the parliament is usually, not usually, 0 hour in the parliament is that hour in which the most important matters of public importance are taken up for discussion. So let us see. When the proposal of opposition are considered, no. When matters of utmost public importance are raised, yes. Interval between the morning and afternoon session, no. When money bill is introduced in Lok Sabha, no. So the straight answer is when matters of utmost importance are taken up, that hour is called 0 hour. So it's a key question which can fall into the general knowledge section as well as in the constitution section. Intentional application of force to one other person is actionable in law. Okay, intentional application of force to one other person is actionable in law. P and D are unknown to each other. When P is about to sit on a chair, D intentionally pulls it away, as a result of which P falls on the floor and is injured. Now D is not liable as P is not seriously injured. D is not liable as such jokes are common in the society. D is liable as he intentionally caused injury to P. D is not liable. So definitely D is liable, and there is only one option with D is liable as he intentionally caused the injury to P. It summarizes the facts and the principle nicely, decently. So pulling a chair may be a joke, but if someone treats it as an offense, you are guilty of an offense. And even in fact, this habit is a very bad habit, but it's very common in the school time. Young people do it, young children do it. So it is advised that you should not do such activities. It can cause into serious injury to someone else. Okay, so be please careful while doing these kind of jokes. Okay, I'm talking here because I saw an option D is not liable as such jokes are common in the society, because it actually is a kind of joke pattern in the society. Friends do this a lot upon each other, but we should be careful. You people are not immature children, you are grown up children, mature enough to understand that these acts are not good, and so we should you should, and we, even I also, should not uh, indulge in such unhealthy jokes. 79. Law does not penalize for wrongs which are of trivial nature. Trivial nature means minimal nature, insignificant, insignificant nature. So, in course of a discussion, A threw a file of papers at the table which touched the hands of B. So, A threw a file of paper at table, which he threw file at table, not at B, at table, but somehow it touched B. So this act is a trivial act, insignificant act. It may have touched B's hand, but it hardly makes any difference. A is liable for his act as it assaulted B. So now, when we talk about assault, assault has to have intention. If A threw the file with intention, then it would have been assault. But look at what he has done. A has thrown the file of paper on the table, not intentionally. He has thrown on the table, but accidentally it touched B, so it's an accident. A is liable for insulting B. Mm, what is an insult here? A is not liable for his act as it was of a trivial nature. A is liable for his act as the file touched B's hand. So this option is C, because it's a trivial act, and definitely no one can be held guilty for such acts. If we are going to make society this sensitive that they are going to rush to the court for each and every small things, then courts are going to be the overburden, and society is going to be hardly jeopardized by that. So it is in the interest of the society as well as interest of the law that trivial cases, okay, which are trivial nature, should not be brought to the court and should not be discussed. This also becomes a kind of case of extra sensitive plaintiff, like we discussed. Someone who is extra sensitive, so he may be here, may feel that he's been violated or he's been insulted or he's been assaulted, whatever, but ultimately this is a case of extra sensitive plaintiff, because the offense is of a trivial nature, ultimately no offense at all. So the practical answer is C. Principle: consent is a good defense in civil action for tort, but the act should be same for which consent was given. Okay, consent is good defense for civil action. B was formally invited to A. B was formally invited by A to his house. B, after sitting for some time in drawing room, moved to the bedroom of the house. A sued B for trespass. That you have trespassed into my bedroom. Oh, what is this happening? Remind me later, I'm sorry. Sorry for that disturbance. Technology can trouble anyone nowadays. So B has committed trespass as there was no consent of A for the entry in the bedroom. Yes, there was no consent for the guest to enter into the bedroom. B has committed no trespass as he entered in the house with the A's consent. Yes, this is also okay. B has interfered with the privacy of A. Yes, he has done it. B has offended A by moving to the bedroom. Yes, he has done it. This is correct. This is correct. Okay, but has he committed trespass? If we look at the trespass, trespass means unlawful entry to someone's house. Okay, so bedroom is a part of house. We are not talking about separate rooms here. So when he has been invited by A, so if he has gone to A's house and on the invitation of A, and without any permission entered into the bedroom. So yes, he has interfered with the privacy. He has offended B as well, but you definitely cannot make him guilty for the trespass. We cannot go with these options. These options are correct, but we cannot go with them because he has filed a case for trespass. We have to discuss in relation to trespass only. So we'll restrict ourselves to option B. B has committed no trespass as he entered the house with the A's consent. Okay, so when he entered the house with the consent of A, then drawing room, bedroom, whatever, toilet and kitchen, they all are part of the house. You cannot keep taking rooms separately and then filing cases at each other like this. People, principle one who dishonestly misappropriates or converts to his own use or sells any movable property belonging to another is guilty of offense of misappropriation. Yes. A takes property belonging to Z out of Z's possession in good faith. In good faith, like I borrow a book from you that I want to read it, and my intention is only to read it and return to you. That is called a good faith. Believing when he takes it, that property belongs to himself. Subsequently, A, on discovering his mistake, without disclosing the actual facts, dishonestly sells the property to a stranger. So he has taken the property out of Z's possession. When he took the property, he had a belief that this actually belonged to him only. Now, sometimes it may happen that two people may have the same book. So other one took the book belonging to other. But now, A, on discovering his mistake, now he has discovered his mistake. Now, what he should do? He should legally go and return it to the things, but without disclosing the actual facts, he dishonestly sells the property. Now, that is a wrong. A may be guilty of theft, but not for misappropriation. A is guilty of an offense of misappropriation. A is not guilty because when he took the property, he believed in good faith that it belonged to him. No, this cannot be an option. A is not guilty, not cannot be an option. Or A is guilty definitely. A is guilty either of misappropriation or A is guilty of theft. Now, principle talks about misappropriation. So we have to stick to misappropriation, and ultimately as well, A cannot be guilty of theft. If we talk about in normal situation as well, we forget the principle. Why? Because in for committing theft, you have to have a dishonest intention of stealing thing. Your intention should be to steal the thing, but here his intention was not stealing thing. Okay, when you are committing theft, you know that property does not belong to me, and then you take it out of the possession in an order to steal it. Okay, but here he has taken the property believing that the property belongs to him. So his intention when while taking the property is not dishonest. So this cannot fall in the category of theft, it will go in the misappropriation. Okay, so it becomes B. A servant is one who is employed to do some work for his employer. He is engaged under a contract of service. He works directly under the control and directions of the master. Yes. In general, the master is vicariously liable for the torts of his servant which are done by the servant in the course of his employment. M appointed D exclusively for the purpose of driving his tourist vehicle. M also appointed C exclusively for the purpose of performing the work as a conductor for the tourist vehicle. So now D is the driver, C is the conductor. During one trip at the end of the journey, C, while D was not in the driver's seat and apparently for the purpose of turning the vehicle in the right direction for the next journey, drove it through the street at a high speed and negligently injured P. Now M could be made liable for the action of C as C was employed under the contract of service. M is not liable as he was not present at the time of accident. M could not be made liable for the act of C as C's act of driving the vehicle was not in the course of employment. None of the above. Now we have to see whether these people are employed by M. They are employees of M. Now fact says that they are employed. Now we have to see what is the course of employment. C is to D is to drive and C is to conduct. Now, what is he driving? What is he doing here? Is he conducting or driving? He is driving. So, whether driving is part of his employment, driving is not part of his employment. So, when he is doing it, he is taking it. He is doing it personally, and now M will not be liable just because he is the employer. So, we'll go with option C. However, however, if this was asked in a different manner, if it was like D asked C to park the bus somewhere, and upon the instruction of D, C did that, then M would have been liable. Okay, but here it is not. So mere jumbling up of words may can change the answer drastically. Okay, so you have to understand things in a quite mature manner as well as a reasoned manner. Waging agreements are void. Now you all understand what is a waging agreement, betting agreements. Okay, gambling. Collateral agreements to wagering agreements are valid. Collateral agreements means agreements which are associated with that particular agreement. Okay, associated agreements. XYZ Bank lends rupees 40,000 to Sabu in order to enable him to award a prize to Randeep, who is the winner of horse race. Later, Sabu refused to pay the price, stating that the horse racing is a wagering contract. Can XYZ Bank recover money from the sub? Now he has taken the money for a wager. Can the bank recover the money from him? Because wagering contracts are illegal. Bank can recover money from Sabu so that payment of prize money can be made to Randeep. No, as it is a wagering contract. Yes, as it is only a collateral agreement to horse racing, therefore the bank can recover the money from Sabu. Horse racing is illegal, therefore XYZ Bank cannot recover anything from the Sabu. Now, but we have to see that contract between XYZ and Sabu. A contract between XYZ and Sabu is simply to lender and borrower. Lending and borrowing. Bank is to lend, he has to borrow. Okay, so is lending and borrowing also illegal? Lending and borrowing is not illegal. So what he uses with that money, how he uses that money later on, that does not alter the liability or the rights of the bank. Bank is entitled to recover it back from Sabu. Okay, so definitely, if the case would have been that he did not pay, if the case would have been XYZ lent rupees 40,000 to Sabu, and Sabu, however, later on did not give it to Randeep. Now Randeep want to recover it. Then Randeep and Sabu's agreement would have been void, and Randeep could not have recovered this 40,000 from Sabu. But bank has given a legitimate loan to Sabu. Now bank can definitely recover it as it is only a collateral agreement. Yes, so now we go with option C. Where a person lawfully does anything for another person or delivers anything to him, not intending to do so or to provide gratuitously, gratuitously means to provide freely, not intending to provide freely, and such that the person takes the benefit of that. The latter is bound, latter means the person who has taken the benefit, other person. Latter is bound to compensate the former for something done or thing provided, or to restore the things or delivered. Now, if someone is doing something not gratuitously, but okay, then other one is liable to pay for the services. Trader A delivers certain eatables at B's house by mistake. B consumes the eatables without asking anything. Which of the following derivations is correct? Now, trader is a trader. He has delivered. He is definitely delivering things for money, but he has delivered at B's house by mistake. But he does not want to. He did not intend to deliver it, but mistakenly he has delivered, and now B has consumed it. B can be made liable to pay for the eatables only if A establishes an express contract between A and B. That there was a contract. B is bound to pay A for the eatables. C, it is discretion of B to make payment. B is not bound to. So the ultimate option by applying the principle comes out to be answer B, because the principle says that if you do something which is not gratuitous and other person is taking benefit, the latter is bound to compensate. So he has done something, delivered eatables which is non-gratuitous thing, and then he has consumed it, he has derived the benefit, now he must restore it. Okay, so it B is bound. Killing is not murder if the offender. while deprived of the power of self control by intense and sudden provocation, causes the death of the person who gave the provocation. Okay. Now, this is we are talking grave and offense committed under grave and sudden provocation we discussed in the class. When someone provocates you in such a manner that suddenly you lose your senses and you commit an offense, then if murder is committed, then murder will be treated as culpable homicide and not murder. And now I will not go into again into murder and culpable homicide. You can refer my earlier slides to understand what is a murder and what is a culpable homicide. But let's now come back to the facts of this case. A man found his girlfriend sleeping in her own bedroom with another man named B. A did not do anything but went to his home, picked up a gun and cartridges, returned to the girlfriend's bedroom with loaded gun but found the place empty. Now A got suddenly enraged by seeing this infidelity of the girlfriend. So what he does in this grave provocation, he goes and brings back a loaded gun, but when he comes, the place was empty. After 15 days, he saw the girlfriend dining in a restaurant without waiting for even a second. He fired 5 bullets, girlfriend died. Now there's a gap of 15 days. Law talks about intense and sudden provocation. Provocation has to be sudden. Now there is a gap of 15 days. Now can we say 15 days is sudden provocation? Now 15 days is a planned thing. So when you kill someone with a planning in a cold-blooded manner like this, then it definitely is a murder. A did not kill his girlfriend under intense and sudden provocation. A could have killed both B and his girlfriend. A could have killed B instead of his girlfriend. A killed his girlfriend under intense and sudden provocation. So our answer is A did not kill his girlfriend under sudden and grave provocation. Okay. Whoever takes away any movable thing from the land of any person without that person's consent is said to have committed theft. During his visit to C's, During his visit to house of C, A asked B, the son of C, to accompany A to the forest. Neither A nor B informed C in this regard. B accompanied A to the forest. During his visit to first, let me understand this question, quite confusing. ACB. During his visit to house of C, C's house, A has gone to C's house. Okay. A asked B. B is C's son. So A asked B to accompany A to the forest. Okay. A or B. No one informed C. Neither A informed nor B informed his father C. And B accompanied A to the forest. Now, whether he has committed theft. Now, let us see the principle. Whoever takes away any movable thing, something which moves, and a thing. So this son B, he is movable, but is he thing? He is not a thing. So squarely, he has not committed a theft here. A has committed theft. No, A has not committed theft. A has not committed theft till B did not accompany him. A has committed theft as soon as he entered house of C. No, A has not committed theft because simply B is not a thing. B is a person. Okay, movable person. False imprisonment is taught wrong, which means the total restraint of a person's liberty without lawful justification. A part of public road had been closed for spectators for a boat race. Boat race on a road, I don't know, but it's okay, we have to read the facts. P wanted to enter, but he was prevented by D and other policemen because he had not paid the admission fee. P was able to enter the enclosure by other means, but was unable to go where he wanted to go. Okay. P was able to enter the enclosure by other means. He had other means to enter, but he was prevented to go there because of these police people. The policeman refused access to where he wanted to go, but allowed him to remain where he was or to go back. P remained within the enclosure and refused to leave. Subsequently, P sued D for false imprisonment. D is a policeman. He said that D imprisoned me within that enclosure. It was a case of false imprisonment, but D could not be made liable for it. So reasoning one is that yes, it was case of false imprisonment, but D could not be made liable for it. D could not be made liable for false imprisonment as he has not touched him. For imprisoning someone, you don't need to touch him. D could not be made liable for false imprisonment as he did not restrict P's movements. Quite convincing. D could not be made liable for forced imprisonment as it did not totally restrict B's movement. So the ultimate answer is this, because though he restricted movement, but imprisonment means you cannot total restraint on person's liberty means you are frozen in some place. But here, if we see, he was allowed to remain where he was or to go back. He could have gone back, but he did not go back. He himself remained in the enclosure and refused to leave. Now, that cannot be called a false imprisonment. So, our answer is option D here. This is not a case of false imprisonment. A person is said to have committed assault when an apprehension is caused in the mind of a person that he is about to use physical force against his body. A abuses B while he was sitting in a moving train by aggressively shaking his fist when B was standing on the railway platform at a distance. Now, he's threatening him with gestures. So let us see the options. A has not committed assault against B. A has caused fear of assault in the mind of B. A has caused apprehension of assault in the mind of B. A has committed assault against B. Now let us see what is A. What is assault? A person is said to have committed assault when an apprehension is caused in the mind of person that he is about to use physical force against his body. Now, can the apprehension be caused in such a manner? See, look at the facts. One person is standing in a moving train, one person is on the platform. Can he literally jump off the moving train and go on to beat that person? Is it practical? No, it is not practical. So, in this manner, though he has made some gesture, but this gesture is not sufficient to cause assault or to cause an apprehension in someone's mind that other person is about to beat him. So, our option is he has not committed assault against B. Sale of liquor is illegal. All agreements relating to prohibited items do not exist in the eyes of law because they are illegal agreements. Okay. A entered into an agreement with B for sale of liquor. A failed to supply the agreed quantity of liquor to B. A can bring a legal action against B. A and B can initiate appropriate legal proceedings against each other. B can bring a legal action against B. B can bring a legal action against B. These kind of options can also be there to confuse you. B cannot bring any legal action against you. Now, sale of liquor is illegal. All agreements relating to prohibited items do not exist in the eyes of law. So, this agreement do not exist in the eyes of law. So, B cannot bring action against A because agreement is illegal. So, any illegal agreement, law does not take care of that agreement. You have to suffer the consequences on your own. Consent is good defense for civil action in tort, but consent must include both knowledge of risk and assumption of risk. Readiness to bear harm. You should be ready to bear that harm. Okay. Assumption of risk means you are ready to take that risk. A lady passenger was aware that the driver of a cab in which she opted to travel was little intoxicated. The cab met with an accident and lady got injured. Now she knew that he was little intoxicated and then also she chose to sit into the car and the car met an accident. Now lady got injured. Lady is entitled to claim compensation as she only knew about risk and there was no assumption of risk. Driver can take the plea that he was lightly intoxicated. Lady is not entitled to claim compensation as she had knowledge of the risk. Lady can refuse to pay the taxi as she had suffered injuries. Now the principle is consent must include both knowledge of risk. Now does she have a knowledge of risk? Yes, she has a knowledge of risk. That what is the risk? He is little intoxicated. Okay, so assumption of risk. Is she ready to bear an accident? No, she is not ready to bear an accident. It is a fault of the driver. So now driver, she is entitled to claim compensation as she only know about the risk and there was no assumption of risk. She did not assume that risk. Defamation is the publication of a defamation is the publication of a statement which tends to lower reputation of a person in the intimation of other members of the society generally. Okay. A writes a highly offensive interrogatory letter about B. A is writing a highly offensive interrogatory letter, that means yes, it is wrong. Derogatory letter against about B and sends it directly to B in a sealed cover. A is liable to B for defamation as the letter is highly offensive and derogatory and directly sent to B. A is not liable to B for defamation since there is no publication of any other person to any other person in whose estimation reputation of B could be brought down. A is liable for B's defamation act is as it has hurt B's self-esteem. A is liable for defamation as latter is highly offensive and derogatory. Now we have to see what is the principle. Principle says defamation is the publication of a statement. Publication, that means statement should reach other people as well. Mere abusing someone will not be a defamation. Statement should reach other people. Now let us see the fact here. A writes a highly offensive and derogatory letter. Letter is derogatory, we agree, and sends it directly to B in a sealed cover. So he sent it directly to B in a sealed cover. So that means ultimately B will open it and read the letter. So that does not become a publication. Nobody comes to know of this letter. So abusing one another may be an offense, but not an offense of defamation. Maybe some other offense. So our answer is A is not liable to B for defamation since there is no publication to any person in whose estimation the reputation of B could be brought down. An agreement may be entered into orally or in writing by conduct. A went to shop of B and picked a toothbrush and gave a check of Rs 20 to B and left the shop. Payment of toothbrush cannot be made through check. A should have carried a currency notice. A did not enter into agreement with B. There was an agreement with A and B. Flatly, this is the answer that there was an agreement. Whoever does not arrest the killer and report the matter to concerned authorities commits an offense. So you are required to arrest a killer, or at least you are required to report the matter to the police if you see some offense happening. A woman sees B, another woman killing a third woman. C. Okay, A neither attempted to arrest B nor informed the authorities. B has committed an offense. So B is killing someone. B has not committed an offense. No, B has killing someone. A has committed an offense. A has not committed an offense. Now B is killing someone. So B has definitely committed an offense. But we are concerned with the principle. Principle says who does not arrest the killer. So who has not arrested the killer or informed the authorities? A neither arrested B nor informed the authorities. So we have to forget B here. We have to stick to A. Whatever A has done, she has committed an offense. So our answer here is going to be option C. There are certain acts which, though harmful, are not wrongful in law. Therefore, do not give legal right to bring action in law to a person who suffers from such acts. Some actions are there which may be harmful but are not illegal. So nobody gets a right if someone suffers an injury due to that particular act. Prakash has a rice mill. His neighbor Shanti sets up another rice mill and offers a tough competition to Prakash. As a consequence, Prakash's profits fall down. He brings suit against Shanti for damages. This is a case of damnum sine injuria, damage without injury. Damage is there, but injury to legal right is not there. So we have done this, so it is easy to solve this question. Prakash cannot succeed in his claim for damages, as it is a case of damage without infringement of an illegal right. This is appropriate, but yes, we have to see the other options as well. Prakash can succeed, Prakash cannot succeed, Prakash may succeed, may not succeed, Prakash can succeed, cannot succeed. So our option ultimately is answer A. A condition to a contract can also be complied with after the happening of the event to which such condition is attached. A promises to pay 9,000 to B on condition that he shall marry with the consent of C, D, E. B marries without the consent of C, D, E but obtains their consent after the marriage. B has not fulfilled the condition, B has fulfilled the condition. So he has obtained the permission after the marriage, and it says a condition to contract can also be complied after happening of the event to which such condition is attached. So condition is attached for marriage and he has obtained the condition after marriage. So as per the principle, B has fulfilled the condition. Now he can go and claim 9,000 rupees. The communication of a proposal is complete when it comes to the knowledge of a person to whom it is made. A sent a letter making a proposal to B to purchase the house. Okay, now these questions are quite confusing. The communication, let us see, the communication of proposal is complete when it comes to the knowledge of person to whom it is made. A sent a letter making a proposal to B to purchase the house of B. The communication of proposal is complete when A sent the letter. For A, it is sent. For A, it is complete. As far as A is concerned, it is complete. But we are talking about proposal is complete from his side, but we are talking about communication of proposal. The communication of proposal is complete when B's wife handed over the letter to B. No, because B is yet to open it and read it. The communication of proposal is complete when B's wife received the letter. No, the communication of proposal is complete when B reads the letter. So communication will be complete only when he comes to knowledge of this communication. So that is the case applicable in option D. So we will go with option D here. Whoever by words or writing conveys to others any imputation concerning any person's reputation is said to defame that person. During a marriage ceremony, he circulated a pamphlet saying that 5. Sister of bride is a thief. She has stolen the shoes of bridegroom. A circulated a pamphlet saying that 5. Sister of bride is a thief. She has stolen the shoes of bridegroom. Whoever by words or writing conveys to others any imputation concerning any person's reputation is said to defame that person. He has defamed the 5. He has called someone a thief, so definitely he is guilty of causing defamation, bringing down the reputation. Causing to an effect partly by an act and partly by an omission is an offense. You are causing something partly by doing something and partly by not doing something will be an offense. Okay. A confined her daughter D in a room. A also did not provide any food to her daughter D. Consequently, D died of starvation. A has committed no offense. A has committed the offense of confining D. A has committed the offense of not providing food to D. A has committed the offense of causing death to D. He has committed both the offense, and ultimately both the offenses led to dying of D. So ultimately he has committed the offense of causing the death of D. An agreement without free consent can be enforced only at the option of the parties whose consent was not free. Okay, an agreement without free consent can be enforced only at the option of the party whose consent was not free. A obtains the consent of B to enter into an agreement by putting the gun on head of B's girlfriend. So he has threatened B by putting a gun on B's girlfriend's head, and B agreed to the agreement. A can enforce the agreement. B can enforce the agreement. Neither A nor B can enforce the agreement. B cannot enforce the agreement. So now, an agreement without free consent can be enforced. It is enforceable only at the option of the party whose consent was not free. So in this case, whose consent was not free? B. So now only who can enforce it? Only B can enforce it. So now B can enforce the agreement. Only B can enforce the agreement. This is a kind of voidable agreement in which option is given to person whose consent was obtained by such method. Either he may choose to treat it as a void agreement, or he may choose to follow it. So now if he wishes to follow it, nobody can stop him from following the agreement. A cannot say it was a void agreement because I put a gun and now I will not fulfill the agreement. A will be bound by his act. Nothing is an offense which is done by a child under 12 years of age who has not attained sufficient maturity of understanding to judge the nature and consequences of his act on that occasion. Himesh, 11 years old boy, picks up a gold ring worth rupees 5,000 lying on a table in his friend's house and immediately sells it to rupees 2,000 and misappropriates the property. Himesh should be protected under the principles stated above because his acts show that he was not sufficiently mature to understand the nature and consequences of the conduct. Himesh would not be protected under the principles stated above because his acts show that he was sufficiently mature to understand the nature and consequences of his conduct. Himesh would be protected because he is below 12 years. Himesh would not be protected because irrespective of the age, stealing is an offense. Now this cannot be the case. Stealing will not be an offense for a kid. Uh, Himesh should be protected. Himesh would be protected, but let us see the principle first. Nothing is an offense which is done by a child under 12 years of age who has not attained sufficient maturity of understanding to judge the nature and consequences. Who has not attained sufficient maturity. Only that kid is prevented or protected. Now let us see, has he attained the sufficient maturity? He saw a gold ring, 5,000 rupees, and then he immediately sold it for 2,000 rupees and misappropriated the money as well. So this kind of kid is definitely having knowledge. So Himesh would not be protected under this principle stated above because his acts show that he was sufficiently mature to understand the nature and consequences of his conduct. So Himesh, though a kid, will be guilty of committing theft. Principle: nothing is an offence which is done by an accident or misfortune and without any criminal intention or knowledge in doing of a lawful act in a lawful manner by lawful means and with proper care and caution. Such a big principle. A takes up a gun, not knowing whether it is loaded or not, points it playfully at B and pulls the trigger. Consequently, B falls dead. B's death is accidental as A had no intention to kill B. B's death is accidental as A was just pointing the gun playfully at B. B's death is accidental as did not have the knowledge that the gun is loaded. B's death is not accidental as there was want of proper care and caution on the part of A. Now let us read again the principle. Nothing is an offence which is done by accident or misfortune and without any criminal intention. No criminal intention is there. Or knowledge in the doing so. He has no knowledge. In the lawful act, lawful manner, means, and with proper care and caution. Now, this person has failed to take proper care and caution. You cannot simply play with a gun. Okay, you have to first test fire it somewhere if you want to play. You have to first test fire it in the open air or somewhere else to know that whether it is loaded or not. So, he forgot to take proper care and caution. So, A's death is not accidental, and he definitely would be guilty for this crime. So we'll go with option D here. Import means bringing some consignment into India on a foreign country, from a foreign country. A consignment from Sri Lanka entered the territorial waters of India. However, this consignment never crossed the Indian custom barrier nor did it enter into the stream of commerce in India. It entered the territorial waters of India. The consignment was imported into India. The consignment will only be imported into India when it crosses the Indian custom barrier. The consignment was not imported into India. The consignment will only be imported into India when it enters the stream of commerce in India. Import consignment into foreign country. These three options all are equally good, but we just apply the principle. Whether it entered into India, it did not enter into India. So whether it will be import when it crosses Indian barrier or whether it will be import when it crosses the stream of commerce, we don't go into that question. We can simply say it is yet not an import to India, and we'll go with option C. Consignment has not been imported to India. Okay, entering into territorial waters of India itself is not entering into the Indian market, okay, or Indian territory. Okay, because you can still go back from the territorial waters, but ship when it lands on the shore and the item is offloaded on the Indian soil, then only usually it will be as an import. Existence of all the alleged facts is relevant whether they occurred at the same time and same place at different times and places. Existence of all the alleged facts is relevant whether they occurred at the same time and place or at different time and places. A citizen of England is accused of committing murder of B in India by taking part in conspiracy hatched in England. Only the fact that A is accused of conspiracy hatched in England is relevant. The fact that a citizen of England is accused of commission of murder in India and a conspiracy hatched in England are relevant facts. Only the fact that a citizen of England is accused of committing murder in India is relevant. A citizen of England cannot be tried in India. Now, what is the relevant fact here? Let us see. Existence of all the alleged fact is relevant, whether they occurred at the same time or place or different time. Every alleged fact is relevant. Now let us see how many facts are there. A citizen of England is accused of committing murder in India by taking part in conspiracy. Now everything is relevant here. The fact that a citizen of England is accused of commission of murder in India and the conspiracy has done England, all are relevant facts. Okay, so we'll go all are relevant facts. All these things are relevant. Okay, we cannot ignore anything. We'll have to take care that yes, he is a citizen of India. England, conspiracy is hatched in England. It is also a crime, and murder has happened in India. It is also a relevant factor. Who has been murdered? B. It is also a relevant factor. Who has been murdered? A. It is also a relevant factor. Acceptance of proposal must be the exact mirror image of the proposal. A made a proposal to B to sell chair for 500. B expressed his desire to buy the said chair for 400. B has accepted the proposal of A. It is not clear whether B has accepted the proposal of A or not. It is not clear whether A made a proposal to B. B has not accepted the proposal of A. Very easy answer. He has made a counter offer. Law never forces an impossible promise. A made a promise to B to discover treasure by magic. Law will not enforce the promise. Law will enforce the promise only at option of A. Law will enforce the promise. Law will enforce the promise only at option of B. This is something impossible. Fancy stuff available in movies only. So law will not entertain such nonsense. So option is A here. So enough for today's class. Now we'll meet in the next class. Thank you.